بسم الله الرحمن الرحيم كلنتي وناكسن داوديا سيدا قيمة لعيارة هوريالكا كوبادا عكتا سوماليلاند تضباط كي أفراد هرقيسة استاديوم باهيتا تلفزيون كقرن كي توسكا عيارتا واحد كوتشر محمد قاوان انجينير عبدي سمد شرماكي عبدي جبريل ودين كاميرا محمد صومالي مبارك بوكاسي عيارتينا وي بلاماتي قيبتي هوري هات العيارتويغا كوحدا غاسان عيدا كقرن كاي عيارتويغا كوحدا وزارة مالية ciyaartayga wasaaradda maaliyadda galabta ciyaarta mid ruuda abay ku ciyaarayaan daawadayaal halka midabka cadaankana gaashaan oo ciidanka qaranka ay ku ciyaarayaan labada kooxood ee galabta ciyaarta socota daawadayaal qaybtii hore waa bilaabantay haatan subeer ee dhaxjoog axmed hindi isku dhibaso mooday maaliyadda ciyaartaygooda markan daafaca kabtan salebaan mukhtaar torino موليد أضي عيارتيغا أحمد هندي يا خضر عسكا سعيد مانو أمين بديعو قيب توير كبيسك عوينين عبدي فتاح تاحو وتيم كوزارة مالية توبر إيدان توبر عبدي موسى دافع وحاو كسو بلابي عبدي غني سيارة بلا جول كبو هيا محمد دوح قلب الدفاع دافع نحبوك عيارتيغا إيد عيدروس علي أمين بديعو مركان محمد دوح هو كبحذي كونا كيكو مركان قعن تورشو عبدي كريم جوتشي كابتنكا كوحدة غاسان كابتنكا كوحدة وزارة المالية سلبان غاسان أفر نبعود بهيستان هوريالكا كوبادا عكتا عاصمة هرقيسة سومالي لان هلكا laba kulan baa laga badiyay tababar iidaana hal kulanna waa badiyay daawadayaal sidoo kale gaashaan hal kulan waa laga badiyay hal kulan waa badiyeen hal kulanna barbardhac bay galeen 4 dhibcood bay haystaan galabta waa kala baxayaan 90 daqiiqo daawadayaal haddii rabiid ma ciyaartuna waxay maraysaa toddobaadkii afraad ee horyaalka kubadda cagta Somaliland xiriirka kubadda cagta Somaliland ayaa bilaabay 22kii bishii labaad 2021 ina dhaaftay horyaalka kubadda cagta xilligaas oo lagu furay waaxool iyo maaliyadda markan mawliidooda ay daafaca kubad sare ciyaartooyga Amiin Badeeco Xamse Sulaac markan qalad baa lagu galay ديو موليد كيو قرعنا عيارتيغا محمد سيدي عبدي كريم جوتي الكابيتانو اسكودي بس مركن قانا وصوب يابين عيارتيغا ميدبك عدانا مدوح حقس وحول مركن كوحدة غاسان كوبت سرا مركن برتنكا جروكا عبدي كريم جوتي مختار تورينو السلباني دافع مركن عيارتيغا كوحدة وزارة المالية أحمد هندي كوبات فرن مانو بيلي سيارة وصوبة هاي جول كواقبتي مركا عيارتويغا عبدي قريب بيلي غاسان مركان صدح كولومبو جول كواهيا عيارتويغا عبدي قريب بيلي كدب كي كواد مركي وكفدي عيارتا صدحدي كولن كلا توبر عبدي موسى وكسو بلابه كوخدا عيارتا سعودتنا قلبتا اسكو ديبسدا وا دغدغو هراب كبدلو ديبه عيارتيغا دافع لوقتا ميدق مصطفى 8 7 لوقتيسا وا كبخدي تاحو عبدي فتاح تاحو مركان قلديا لغو غلاي 19 ايغس وزارده معلنتي تمرتب وكسو وريغي مركان waxa uu ka tirsan kooxda wasaaradda maaliyadda ee heerka koowaad horyaalka kubadda cagta Somaliland 9 dhibcood tababar dir dhawaa ka horkacaya tiimka Hargeysa City Club ee dawladda hoose 7 dhibcood Cabdi Riyaad ee ciidanka asluubta 7 dhibcood Yaasiin Bayare wasaaradda ganacsiga 5 dhibcood Jamaal Janta ciidanka booliiska daawadayaal 4 dhibcood tababar Cabdi Muuse sidoo kale 3 dhibcood waxa fadhida ee kooxda wasaaradda maaliyadda tababar iidaana horyaalka kubadda cagta wali la isma gaadhin daawadayaal oo ciyaaro badan baa dhiman xilli toddobaadkii afraad galabta uu ka bilaabmay Hargeysa Stadium oo isniina isku dhibaso عيدروس علي عيدروس برتمها جرونكا زكريا ديو سلاع حمسه سلاع وصوبا سمركا عيارتيغا حمسه سلاع كونتونيشن سوبر دحجوج marka waracdeynaya عيارتيغا lambarka 6 waa ka soo baxday lugtiisa زكريا ديو خدك دحبو كعياريا مركن يسكو ديبشو وصو بلابيا زكريا جوتشي عبدي كريم الكابيتانو سليمان مركا وكدفاع عليه يا كابتن ماليدا يا كابتن حديقها العكتا سليمان كالو يسكو ديبشو مركا عيارتيغا سوبر موليد اوداي مركا وكبحلي لوكتيسا subeer dhexjoog lambarka lixaad wasaaradda maaliyadda khadka dhexa buu ka ciyaaraya qaybtii hore ciyaartu waxay maraysaa natiijo gool la'aana galabta shabaga labada golwada golhaya warsame baa goolka u haya wasaaradda maaliyadda halka golhaya siyaarana uu goolka u haya kulanka kooxda gaashaan maalinta beriya haddii rabbi idmo cayaarta daawadayaal ay ku ballansan yihiin wasaaradda ganacsiga iyo kooxda ciidanka asluubta oo min 7 dhibcood isla fadhiya berri bay daawadayaal kala baxayaan haddii rabbi idmo kulanka cayaartan socotana haatan gaashaan iyo wasaaradda maaliyadda kubad sare la geenayaa dilinta 18 cabdikariim guuji 63 goolam la marka waa la difaacay isku dhiiba Soomaaliyada kontra يا محمد دوح محمد الدوح دافع دحابو كعياريا لمبركا افراديد يوسف دفاع دح سيدتني افر عيدروس علي دافع لوكتا بدحبو كعياريا كلن كقلبتا جول هياها مركن عيارتيغا موليد اودي يمين بديعو وكبخدي لوكتيسا مركن عيتو زكريا ديو عالمي ستار مركن افرتن يلا باسي زكريا ديو وكبخدي لوكتيسا gaashaan ciyaarta galabta socota daawadayaal qaybtii hore waa ciyaarayaan wasaaradda maaliyadda gacan tuurasho mawliid oday subeer marka ciyaartoyga mo oday hindi ya mawliid oday waa soo kubad sare marka 17 ciyaartoyga gaashaan baa raacdaynaya haatan ciyaartoyga bar 17 markan dilita stadium حمزة شلاع محمد شيده محمد شيده ومحمد وكبح ذي مركز لوكتيسا موليد أضي وأوصل نقضي كوري أي عيار يكوحدة قاشان قيبتا ويرركا عبد الكريم جوتشي قيبتا ويرركا عيارتيغا 17 قيبتا ويرركا بوكو عياريا حمزة شلاع خد كان حبو عياريا زكريا ديو وكوبت سميها عيارتا قيبتي هوري قاشان وزارة مالية أحمد هندي قلبتا اللمبر كسيديدات بوكو علامة زي مركنا gacan tuurasho haatan ciyaartoyga gaashaan wasaaradda maaliyadda eber gaashaan eber 90 daqiiqo ciyaartani waa isbedeli doontaa haddii rabbi idma daawadayaal markan ciyaartoyga mustafa umme daafaca markan saciid lambarka 20aad waa soo farsamaystay kubad fura subeer dhex joog markan difaaca galabta comeback bay samaynayaan degdeg baa loo soo noqonaya ciyaarta waa adag tahay 4 dhibcood iyo 3 dhibcood bay kala fadhiyaan midabka huruuda wasaaradda maaliyadda 3 dhibcood bay fadhiyaan gaasaan midabka cadaanka 4 dhibcood bay fadhiyaan dhanka kala horeynta markan mawliid oo soo baasay ciyaartoyga lambarka 11 عيدروس علي امين بديعه واسحدنayaan ciyaarta markan عيدروس oo ka baxday lugtiisa mo oday caalami mo oo baasay marka ciyaartoyga subeer dhaxjooga zakariya diyo waa baxday markan zakariya baaje buu caan ku yahay 42 khadka dhexe 4 kulan oo xidhiidh buu ka ciyaaraya markan ciyaartoyga علي وباسيا دافع لوكتا بديحه قلبت عيارته سعوتا محمد كوري برتمها جرونكا احمد هندي تاحو يستار سقال مركا عيارتويقا عبدي فتاح تاحو ميسي مركا جول هيا عبدي غني زيارة وصوبحي زيارة بلا جول كبو هيا اللباتانية اللي يحبكوا على متسي محمد دوح وباسي مركا عيارتويقا اللمبركا فرادة يا باسي هاتن عيارتويقا محمد دوح markan ciyaartoyga Gucci waa baasay ciyaartoyga Gucci waa ka baxday Subeer شلاع عيتو markan ciyaartoyga waa ka dheeraatay go'ay warsan soo baxay amiin سيكوب عيارتيغا مصطفى علمي مصطفى وصري مركا عيارتيغا يا دفع سميديغا غاسا سعيد كنترول كونترا ماليدا يسكو ديبشو سوبر دحتوغ
daawad halkani waa Iftiin Somali TV si aad noola socotaan waxyaabaha soo galino page-kayga la kare siina share garee si aad u daawato barnaamijyo ku xiiso geliya iyo warar xaqiiqada ku saabsan sidoo kale kala soco sportiyada
ciyaartii dhaxmartay ciyaartooyga ciidanka
daawad halkani waa Iftiin Somali TV si aad noola socotaan waxyaabaha soo galino page-kayga la kare siina share garee si aad u daawato barnaamijyo ku xiiso
sinaanta sideed iyo tobanka waa ka gudbeen haatana natiijada kulanka galabta eber iyo eber bay maraysaa Hargeysa Stadium qaybtii hore lama kala dhalin daawadayaal waa kuma wiilka u booqan doona labadan kooxood sideed iyo tobanka dilinta sideed iyo tobanka yaa booqan doona shabaga Gucci Alcapitano 63 Golatula اليوم يومك يا جوتشي اجس من ميلانو يا جاشان عيار نتيجة وحاي مريسات وضيا ليبري إبر وين قلب الدفاع خضر عسكا مختار تورينو سليمان كالو أودي موليد أودي عيار تيغا وصوباسية قاسان ويرر برقوية ماليدا مانو كانترول تاحو كوبت سربا كان مركن تاحو وبحضي دين علاق بيو بحضي مركنا دين علاقي كواد بالله يا عيارة الصعوطة قيبتي هربي صعوطة نتيجة عيارتنا الصومالي سكور بعد كلا سعونيسان هوريالك كوبت عكتا gaashaan iyo maaliyadda natiijada ciyaartanna marka ay soo dhammaato telefishinka qaranka Somaliland ayaad kala soconaysaan daawadayaal galabta ayaa geli doona xikaayatu bukase galabta ayaa geli doona rikoorka ciyaaraha ee telefishinka qaranka eber iyo eber baa la isla marayaa ciyaarta toddobaadkii afraad ugu adag wasaaradda maaliyadda iyo kooxda ciidanka qaranka gaashaan egas cabdi muuse cabdi timo egas gaashaan cabdi fataax shambidiro egas gaashaan iid jibriil egas gaashaan ciyaartooy badan baa soo maray kooxda taariikhda badan kula kubadda cagta Somaliland Hargeysa Stadium daawadayaal qaybtii hore koornihii koowaad bay heleen dhinac laagii koowaad baa la keenayaa dilinta 18 weynak cabdi qani bila siyaaro weynak cabdi kariim guuji weynak sakariya baashe diyo oo marka waa lagu laagayaa dilinta 18 gool amla galabta ciyaarta socota ya Yusuf Osila subeer dhaxjoog waa laagayaa markana dilinta 18 la keenayaa laaga dheer koona kiga waa dhinac laagii koowaad dilinta 18 سليمان كالو احمد هدي بركه واك دفاع عيارتيغا مصطفى عبد الكريم جوتشي 63 لحدن يسدح الكابيتانو وصومري الشهاده عبد الكريم جوتشي كروس بركه واك بحضي وكديرات ميلدر باك باس كوبت سره عيارته سعوتا 20 دقيقه الاسلام مريا ابريه ابرا التلفزيون كقرنك عيارته كسعوتا داوديالا barta Facebook SLN TV-na waad kala soconaysaan horyaalka kubadda cagta waxaana baahinteedii ku jira injineer Cabdi Samad Sharmaake Maxamed Somali Maxamed Gaabane dhinaca muuqaalka kamaradaana Cabdi Jibriil ciyaartana sidoo kale waxa ku sugan qaadire kabadhe horyaalka kubadda cagtana daawadayaal waxa uu noqonayaa toddobaadkii afraad telefishinka qaranka aad kala soconaysaan sidoo kale daawadayaal ciyaarahani waxa ay gelayaan dhanka dhibcatirsiga 9 dhibcood Hargeysa City Club waa dawladda hoose loo garan ogayay bay fadhiyaan 9 dhibcood ciidanka asluubta 7 dhibcood iyo Cabdiriyaad Yaasiina Bayare tababaraha koowaad wasaaradda ganacsiga 7 dhibcood bay fadhiyaan kulanka berina waa kulanka lagu kala baxayo booska kaalinta labaad cidii lugta ku dhalisa fadhiisan doonta cidii shabaga booqata aadi doonta kaalinta labaad horyaalka kubadda cagta Serie A Somaliland waxa uu marayaa marxaladii afraad ee toddobaadkii afraad markan ciyaartooyga kooxda wasaaradda maaliyadda warsame goolka kubad sare bartamaha garoonka waa la isla soo aaday maxamed dooha gacan bay ku dhacday markan garsooraha calanka ayaa qabtay maano markan yellow card buu qaadanaya maano ciyaartooyga Saciid lambarka 20aad maano yellow card red card garsooraha inuu eegi doonaa kolba
كلا يسوي بس كلا بروحوا جنبي
حتى تونس بتخرج من المدينة
والله كده المشتاق يا حلالي عندنا بتاع ولا قال يا أنا كسافيو
إيه أنا يرسل هذا مساعدة مصابنا إيه يا حق أكثر وأطلع وطيب ده عندي كمان
وين لكن المشكلة يا مصر عايزين
jeclaayay idba kuma quure u dholdholiya daymantii haweenkay dhowrsantaan jeclaayay idba kuma quure u dholdholiya daayaha u rooney dhabti egmadaaday u dharagtay naftayde daayaha u rooney dhabti egmadaaday u dharagtay naftayde kolkaadii dhawaaqda naftu farax la dheesha qosol baan la dhacayaa kolkaadii dhawaaqda naftu farax la dheesha qosol baan la dhacayaa ku faanay ibba kuma quudhe waan ku dhowrsadaa daymantiyaluushan dhabtiitaan ku faanay ibba kuma quudhe waan ku dhowrsadaa luquntaadan dheer iyo dhimirkii laxaadka waxaad tahay dhammaystiran luquntaadan dheer iyo dhimirkii laxaadka waxaad tahay dhammaystiran kolkaadii dhawaaqda naftu farax la dheesha qosol baan la dhacayaa kolkaadii dhawaaqda naftu farax la dheesha qosol baan la dhacayaa kolkaadii dhawaaqda naftu farax la dheesha qosol baan la dhacayaa naftu muhato marmi waydo musanawdo ku dulmeerte meelan jooga baaday muuqdo midabkaagay hormaraaye naftu muhato marmi waydo musanawdo ku dulmeerte marwadu maro ku metala marma xidhate marwadu maro ku metala marma xidhate miyirkii bay la tagtee meeday booyo meeday away maan qaatee meeday
وزارة مالية وأحمد هندي يا مركن كروتو جول أمين بديعو 7 ماليدا حديقها لعقتا قلبتا وانليا جول كيكو وانا عيارتا داوضا يالا يا أمين بديعو ماليدا هالجول بمرك الله هرمرينا يا أبناء ويدانا أبناء وارقيس استاديوم حديقها لعقتا ايقس وزارة ماليدا هالجول بيسبق قارسيين وأمين بديعو يا دليي ويل كلمبر كتضبات كو علامة سنة ميدب كهرودا هالجول يبر بالا مريا هرقيس استاديوم والله ماليدا هالجول غاسان يبر غاسان هالجول بالا قدلي عيار سقيبتي هوري ايد يوسف جوتشي اللي احنا يسدح الكابيتانو marka ciyaartooyga isku dhibasho mawliid qurcin waa ka baxday marka ciyaartooyga guuji lugtiisa waa ka baxday يا كيو موليد هالجول يا إبر بمرسى نتيجة عيارة داوود يلا أمين بديع رقم 7 تيرا لمبر كتضباط وزارة المالية يا شبكة بوغ قيبتي هوري هالجول يا إبر بمرسى عيارة قلبتها هربان دي كل شيء مركنا والله ما صادالين كرو هرجيس استاديوم سقاشن دقيقة عيارتيغا عيدروس علي وعيتو وكبحد لوكتيسا كوري محمد كوري مركن عيارتيغا لوكتيسا وكبحد يسكوني بس عيارتيغا عبدي كريم جوتشي وباسي ليبان جوروتو شونا يا ليبان نمبر 17 وودنا وين قلبتها عيارتويga gaashan fursad dahabiya buu khasaariyay laastimaan buuha waana ودنا وين عيارتا امين بديعو اليوم يومك 7 وامين ماليدا الشهداء بديعو مركنا وصول عيارتويga laga difaacay cayaartayga gaashan isku dhibasho sulaaca caga dahableh xamsa guji alkabitano waa baas marka cayaartayga ya guji waa ka baxday marka lugtiisa faawal targada qalad toosa baa dhacay ama bareera cayaartana yellow card maaliyada daafaca lugta midig ayaa la siiyay daawadayaal mawliid oday kaarka huruuda abuu qaatay ida sfarat ahmarat hadiiba ay huruudu timaada daawadayaal casaan baa xigaya عيارتنا جول يبر بمرسى يولمبر كتضباط يا شبكة جول هاي السيارة بوغدي قيبتي هوري إلا هدنا جول يبر بالله إسلام ريا كنتون يسن حمسي السلاعة حمسة سلاعة حمسة السلاع مركان كوبت سربا كان عيارتيغا الدافع هو صو دفاعي خضر عسكر ودفاعي هاتنا هل عيارتي بحالة دي سادك تهي قرصورها عيارتها كتبا وقليي مختار تورينو دافع وزارة المالية يا هرقيسي استاديوم تضبات كي تقي داوضي المالنتي تجمعيه وزارة بيها هي دولة دوسي هرقيسة وحا داوع حليسة وقاري الشرماك عيارتي الشرماك وقيبتا ويرك كعاويني حلي لوغو تلقالي مدة أفرتن عشاين وكم مغنان دونو دانك عيارها كبدا عكتا ولو نكوحدي ay soo saareen xilliga uu cayaaraha ku soo noqon doono natiijada cayaartana haatan waxa ay maraysaa daawadayaal eber iyo eber عيارتا lagu daray daawadayaal qaybtii hore waa soo dhamaatay 45 daqiiqo haatan additional time waqtiga dheeriga cayaarta 2 daqiiqo ayaa lagu daray haatan Hargeysa Stadium maaliyada hal gool gaashan eber qaybtii dambana daawadayaal waa la isku soo dhasan doonaa walow haatan natiijada cayaartu ay marayso eber iyo eber hal iyo eber oo qaybtii dambe amiin badeeca uu dhaliyay cayaartana taageerayaal badan baa fadhiya qaybta galbeed ee garoonka Hargeysa Stadium xilli cayaartana daawadayaal ay tahay toddobaadkii afraad oo bilow ah waa maalin isniina toddobaadka afraad ee horyaalka kubadda cagta Somaliland sidoo kale garoonka waxa ku sugan gudoomiyaha xiriirka kubadda cagta Fuad Ahmed Ali gudoomiye ku-xigeenka xiriirka kubadda cagta Khadar Jilaal Jaamac horyaalka kubadda cagta Somaliland mid xiiso leh uu noqonaya kadib markii afar toddobaad oo xiriir la ciyaarayay toddobaadkii afraadna uu maanta bilaabmay maalinta bariya ciyaartan haddii aan daawadayaal idin xasuusiyo maalinta bariya waa 7 dhibcood 2 kooxood oo kala haysta waa tababare Cabdiriyaad iyo tababare Yaasiin Bayare isku soo noqodka iyo haatan Foosi
muwaaribu kaasaad baad u mahadsan tahay kulanka xiisaha badan ee dhexmariyay labada kooxood maaliyada iyo gaashan oo ha kulan xiiso badan oo labada kooxoodba ay soo bandhigeen ciyaar qurux badan kulankuna uu hadda marayo hal gool iyo eber ciyaarta haafkeedii hore kulan xiiso badan labada kooxoodba ay wada ciyaareen waxaan odhan karnaa labada kooxood ee kulankan ay wada ciyaarayeen xiisaha badnaa waxa uu ahaa ciyaarahoogii toddobaadkii afraad si toos ah hadda u bilaabmay harsan oo haafkii dambe ee ciyaarta ciyaartoygu qadar nasashaah ay soo qaadan doonaan labada kooxoodba qadarkaasi ka bacdi waxa ay isku soo noqon doonaan labaduba garoonka iyagoo haafkii dambe ee ciyaarta uu ahaa ciyaar aad u xiiso badan labada kooxoodba ay soo bandhigeen awoodooda ciyaartoyga ay ku soo galeen haafkani waa haafkii macallimiintu ay wax ka soo bedelayeen kooxda tale iyo tusaale iyo goobaha amaba qaybaha uu khaladku uu ka jira ay ka soo sixi lahaayeen walow ciyaartu ahayd mid isku dheeli tiran oo labada kooxoodba ay isku dhigmayeen oo aad arkaysay difaaca iyo weerarka iyo dhexdaba siday iskula jaan qaadiyeen ay labaduba ay ahaayeen mid qurux badan ciyaartu waxay ku soo gabagabowday 1 gool iyo eber haafkii hore ciyaarta ay ku hogaaminayso kooxda Maaliyadu sidoo kale koobkii Sooyo Cup labadan kooxood ayaa iskugu yimid kulankii finalka oo ahaa kulankii ugu quruxda badnaa tartankaasi la ciyaaro ay kooxda Maaliyadu kooxda Gaashan ay kaga guuleysatay tartanka Sooyo Cup ay ugu dambeeyay koob la qabto labada kooxood hadda wareegii afraad aan idhaahday horyaalka heerka koobaad caasimada Hargeysa ay mar kale ay ku kulmeen garoonka guud ahaan waa uu buuxaa taageero tiro badan bay labada kooxoodba ay wataan oo labaduba ay ku ciyaarayaan mahdi jawaase ayaan u yeeri doonaa oo isagu ka mid ah howlwadeennada sida joogta ah maalin kastana uga shaqeeyo garsooro weyna ahaa mahdi ku soo dhawow telefishinka qaranka Jamhuuriyadda Somaliland oo si toos ah ugu jirna live-ka kulanka xiisaha badan bal ka warama tartanka horyaalka sidoo ilaa hadda u socdo
aad iyo aad baad mahadsantahay maxamed foosiye TV-ga qaranka Jamhuuriyadda Somaliland kolay tartankii si habsami socda ee horyaalka heer qaran ee heerka koobaad iyo heerka labaad iyo heerka saddexaadba si habsami uga socda maanta wuxuu galay wareegiisii afraad ee heerka koobaad iyo heerka labaad iyo heerka saddexaad oo maanta wareegii afraad inoo bilaamay alxamdulilah si habsami socda qurux badan bay u socdaan maanta kale waynu ognahay ciyaar aad u xamaasad leh ayaa socota waxay ka dhacaysaa garoonka ciyaarihii waliba ciyaaraha ugu adag ee lagu jecel yahay Somaliland oo ah kooxda horumarinta wasaaradda maaliyadda iyo kooxda ciidanka qaranka ee Gaashan waana runtii ciyaartii imika uu haaf ku soo dhacay hal eber ciyaartuna waa ciyaar adag dadweyne badanna ay runtii ay ka soo qayb galeen waxa kale oo aan xusid midan oo isna heerkii labaad isaguna socdo ciyaar ka horeysa dhacday ciyaarta soo dhex martay ciyaaraha u xamaasad iyana la mid ah ciyaartan oo kale kooxda wasaaradda warfaafinta ee qaranka Jamhuuriyadda Somaliland iyo kooxda cadaaladda oo runtii 3-1 ay ku soo dhamaato ciyaar adag ahayd oo iyaduna ay warfaafintu ay raacday waxaad moodaa in aad la iskugu dhow yahay ama waxa la kala sareeya ay yihiin dhibic iyo laba dhibcood ay kala yihiin waxa kale xusud madow ciyaaraha Britol iyaguna dhacaya laba ciyaarood oo runtii iyaguna qaaliya oo ciyaarta koobaad iyo ciyaarta labaad midna heerka koobaad tahay midna heerka labaad tahay ciyaarta heerka labaad ee dhacaysa Britol waxay noqonaysaa kooxda wasaaradda waxbarashada iyo kooxda wasaaradda horumarinta beeraha runtii wasaaradda waxbarashada waliba hogaaminaysa kaalmaha labaad ku jirta tartanka heerka labaad maadaama macallintu ay hogaaminayso isaguna xiiso gaar ah leh oo aad la isku dhow yahay isna la isku dhow yahay sidoo kale waxaa jira ciyaar kale iyaguna isla heer horyaalka heer qaran oo dhaci doonta Britol insha Allah taala wasaaradda ganacsiga iyo ciidanka asluubta oo iyaduna ciyaar kale ka xamaasad badan waxaad moodaa in marmar ka sii dambaysa uu sii qurux badnaanayo ciyaaruna ay sii adkaanayaan runtii waxaan aad uga mahad celinaynaa maamulada kooxaha heerka koobaad iyo heerka labaad iyo heerka saddexaad soddonka kooxood maamuladooda iyo macallimiinteeda sida quruxda badan ee habsami socodka ee waqtiga iyo sharciga intaba ay ugu dhogan yihiin aadna waan ugu faraxsanahay insha Allah taala waxaan rajaynaynaa in sidaa iminka uu socdo oo si qurux badan uu ugu dhamaan doono idinkana sida habeen iyo maalin baad heegan kugu tihiin dhalinyarada Somaliland aad u dhiirigelinaysaan telefishinka qaranka iyo hawladanadiisa guud oo runtii Maxamed Gaabane iyo Cabdiqaadir kabadhayo dhamaantood ay halka Xasan iyo dhamaantood iyo Soomaaliya iyaguna aad oo rag badan oo dad saaxiib ahayn oo kubadda soo ciyaar jirnay iyaguna aad baan uga mahad celinayaa in dhalinyaradood maanta u hiliyaan
mahdi aad baad ugu mahadsan tahay sidaad noogu sharaxday kulamadii maanta dhacaya kuwa bari dhacaya mahdi garsooro weyn baa tahoo garsoorka wax badan ka garanaya intaanan horta khaladaadka garsoorka ka dhacaya garoonka aynaan u gudagelin waxaa jira ciyaartooyga ciyaaraya waxaad moodaa si agressifnima inay dhammaantood u ciyaarayaan hadday noqoto khalad yaroo wax yar ahaa inay dhammaantood qaylinayaan macallimiintu ha ugu darnaadaan mararka qaarkood aad maqlayso waxaan lagu doodi karin inay ku doodayaan bal ka waran qaybta aan shaxmarinta mararka qaarkood aanu garsoorka dhexe arkayn
runtii horta isku wada mid maaha waxa weeye qayb gaara bay ka mid yihiin kuwaasoo kale oodoo kale ama qaylinayoo kale laakiin kuwaana waxa inooga yaalla sharci baa inooga qoro inooga yaalla ciyaar walba markay dhammaato ribood baanu bixinaa waan u gudbinaa maamulkooda iyo weliba macallimiintooda waxaan rajeynaa insha allahu tacaala iyaguna inay dee akhlaaqiyan way fiican yihiin laakiin oodaya waxaasna etigiska ay ka baxsantahay kubaddooda ay raacdaan oo ay moodo inay isleeyihiin caalamka ka dayda laakiin waxaan rajeynaa insha allahu tacaala in waqtiyada soo socda waxaan ay naga xidhmi doono maadaama aan arag horyaallo sidan oo kalea iyo ciyaaro joogto ah aanay helin oo ay maanta hiil qaran ay heleen insha allahu tacaala taana waxaan rajeynayaa in iyaduna inaga soo xidhmi doonto mana badna waa dhowr qof ama waa dhowr ciyaartooy oo markoodii horeba aad moodo akhlaaqdoodu inay aanay ficnayn kuwaana horaan uga kuwii horena waa kuwii looga ganaaxay rag badan oo ka mid ah oo dee itigiska ka yara baxsan iminkana waa midmidhiyo kuwaan insha allah rajeynana inay
waxaa jira mahdi khaladaad badan oo garsoorka ah ciyaar walba waxaad arkaysaa ciyaaraha qaar weliba yaana oran ciyaar walbe kooxo ka cabanaya garsooro keliya lagu soo celceliyay iyaga laftarkooga way jiraan garsoorku khaladaadkan uu samaynayo sidee lagu yarayn karaa
runtii horta ilaahay ha ka siiyaabaa leh agaasimaha waaxda wasaaradda dhalinyarada ciyaare cabdirashiid caydiid yaasiin baa tababar habeen iyo maalin bay siinayeen garsoorayaasha tababarkoodii way ka soo baxeen oo waan uga mahad celinaynaa wasaaradda iyo weliba cabdirashiid caydiid oo isagu dee ka ahaa kaalinta koobaad waan uga mahad celinaynaa wixii qaladaada ee naga dhaca kolley waa technical error waa iman karaan adduunkaba de iyadoo ay wax walba ay haystaan hadday moral tahay iyo hadday tababar tahay gudaha iyo dibaddaba ayaa haddana qaladaad ku dhacaya faar haddana hameen walba la keenaa waxaan jecelahay insha allahu tacaala qaladaadka garsoorka inaanu yareyno waxaan rajeynaynaa inaanu dhaqso aan ugu soo kordhin doono adeega faar ee caawiyaha garsoorka taasoo yareyn doonta qalad waxaa jiroo kale garsoorayaal heerka labaad ahaa oo la ganaaxay oo lagaba saaray loo dhaadhiciyey sida waxaana iminka dhici doonta haddii laha yidhaahdo garsoorka qaldama ciyaartooyga kale inaan ganaaxu ku dhici doonin laakiin garsooraha laftirkiisana uu qaladaadka uu galo iyo dembigu galo isagana lagu qaadayo lagu ganaaxayo waxaana rajeynaynaa maadaama waxaana barbilow inoo yihiin garsoorayaal badan oo 20 garsooreyn ka badan baa ku soo kordhay oo iminka jiilka ku cusub garsoorayaal hore oo inaga waaweynaa baa jiray oo daalay waxaan rajeynaynaa haddii laha yidhaahdo inaanu qaladaadka aanu yarayno waxaad moodaa maalin ka dambaysa inuu soo yaraanayo waxaa jira garsoorayaal kale oo ku soo noqnoqda ciyaarta kuwana waxaan rajeynaynaa sida ciyaaruhu kale ahmiyad badan yihiin garsoorayaashuna u kala khibrood badan yihiin inaanu haddii ilaha yidhaahdo aanu garsoorayaasha aan ugu soo xili doono haddii ilaha yidhaahdo waxaana jiri doona garsoorayaal kale oo aan la ogeyn oo aanu soo dalici doono haddii ilaha yidhaahdo heerka labaad iyo heerka saddexaad qabta oo garsoorayaal eeda qabta ka fiican waan rajeynayna
by Kenya and which, pursuant to the decision of the court, being no objection by either party, the court has decided that copies of the written pleadings and the documents annexed would be made accessible to the public upon the opening of the oral proceedings. Further, in accordance with the court's practice, the pleadings and documents annexed will be placed on the court's website from today. I would now like to welcome the delegation of Somalia. I note that the agent and 3 other members of the delegation are present in the Great Hall of Justice, whereas the co-agent and other members of the delegation will be participating by video link. In accordance with the arrangements for the organization of the proceedings, which have been decided by the court, Somalia will have 3 hours today and an hour and a half tomorrow, Tuesday, 16 March 2021, to present its oral arguments. I further note that, as indicated in the registrar's letter of 11 March 2021, Somalia will have the opportunity by 10 a.m. on 22 March 2021 to file written comments on the materials that were produced by Kenya. In this first sitting, Somalia may, if required, avail itself of a short extension beyond 6 p.m. in view of the time taken up by the opening part of these oral proceedings. I now give the floor to His Excellency, Mr. Mahdi Mohammed Ghaled, Agent of Somalia. Your Excellency, you have the floor.
Can I remove? Bismillah ar-Rahman ar-Rahim. Madam President, distinguished members of the court, good afternoon. It is an honor and a privilege to represent my country in these proceedings. I come before you today carrying the hopes of the Somali people with me. We have confidently placed matters of utmost national importance in your hands, and we have done so with complete trust in your wisdom and fairness. We have full faith that this court will decide this dispute with our neighbors, our sisters and brothers, justly in accordance with international law. Madam President, members of the court, it was more than 6 years ago that Somalia first came to this court to vindicate its rights under the law of the Sea Convention. It was not an easy decision. Somalia was and still is recovering after decades of grave challenges. We have endured civil war, humanitarian disasters, and the scourge of terrorism. But step by step, Somalia is putting its house back in order. Since 2012, Somalia devoted the bulk of its energies and very limited resources inwards to critical domestic concerns, including rebuilding public institutions and safeguarding the security of our people. While there remains much that to be done, we have made substantial progress. Rebuilding our house also means tending to our fences with our neighbors. We hoped that it would be possible to settle our dispute with Kenya bilaterally through negotiations. Unfortunately, that proved impossible. Our respective views were too different and too firmly held. That is why we are here today before you. Unfortunately, some of our brothers and sisters in Kenya appear to misinterpret our actions. There are those who view Somalia's decision to initiate and pursue these proceedings as an unfriendly act. For example, at that time, these oral proceedings were initially scheduled to begin. The majority and minority leaders of the Kenyan National Assembly tabled a motion to, among other things, call on the government of Kenya to express to the United Nations the Republic of Kenya's protest against the assertion of jurisdiction by the International Court of Justice over the maritime boundary conflict between Federal Republic of Somalia and the Republic of Kenya. And explore other lawful and constitutional mechanisms for protecting the territory of the Republic, including deploying the Kenya Defense Forces to the subject boundary to undertake the responsibility of protecting the sovereignty and territorial integrity of the Republic. We understand that passions about border issues are easily inflamed, but the matter of delimitation of the maritime boundary between Somalia and Kenya has been entrusted to the judgment of this most distinguished court. The Charter of the United Nations compels all member states to resolve their disputes by peaceful means, including by judicial settlement. By presenting its application, initiating this case after negotiations failed, Somalia was carrying out an objective of the Charter by seeking judicial settlement of a dispute that the parties were unable to achieve on their own. And the court itself confirmed the priority of Somalia's recourse to judicial settlement when it agreed that it had jurisdiction over the case. This is as it should be, Madam President, because only with the court's assistance can the impasse be broken, a settlement be found, and legal certainty delivered. We are therefore deeply concerned that Kenya has decided not to appear at these hearings. In Somalia's view, this is inconsistent with Kenya's obligations under the Charter, the statute and rules of the court, and as a party subject to the jurisdiction of the court in these proceedings. It is also inconsistent with respect for the rule of law. Certainly, Kenya has no grounds to complain about its treatment by the court. Indeed, in Somalia's view, the court has been generous in accommodating Kenya. It granted 3 requests from Kenya to postpone these hearings for a total of 18 months. It allowed Kenya to submit more than 4 pages of new documents on the eve of these hearings, more than 2 years after the written pleadings in this case closed. The court even allowed Kenya to submit a 315-page supplemental legal pleading, which is not contemplated by the rules, barely 10 days before the start of the hearings. Kenya thus has been afforded due process in abundance. Fortunately, it is a regrettable decision to boycott the oral hearings cannot prevent them from proceedings, nor can Kenya's defiance prevent the court from fulfilling its mission. And after taking account of both parties' voluminous submission and duly deliberating on them, rendering a final judgment that is final and binding on both parties, which establishes a definitive and permanent maritime boundary between our 2 states. That judgment is critical to Somalia because it will enable us to secure access to the maritime resources to which the law entitles us, resources that are potentially some of Somalia's most valuable assets, is vital to ensuring the future stability and prosperity of our nation. Those resources will play a major role in assuring Somalia's continued development in a way that benefits all our people. Madam President, on the merits, this case is actually quite straightforward. Both Somalia and Kenya are parties to the United Nations Convention on the Law of the Sea. The court has developed a rich jurisprudence interpreting and applying the provisions of the Convention regarding the delimitation of maritime boundaries. In case after case, the court has applied the 3-step method, and it has now become standard practice. This begins with the drawing of equidistance line from the land boundary terminals. Fortunately, there are no technical, geographical, or other impediments to the construction of the equidistance line from that point. The second step of the process is the examination of the coastal geography for relevant circumstances that might warrant an adjustment to the equidistance line. In Somalia's view, there are none. The coastline is entirely regular, without any anomalous features, and there are no offshore features that distort the equidistance line. The final step of the process is to assess whether significant disproportionality results from the equidistance line. As we have shown in our written pleadings, there is none. There is thus no reason to depart from or adjust the equidistance line. In Somalia's view, the equidistance line is the equitable solution that the law requires. Kenya, of course, would have it differently. It urges the court to depart from the approach followed in every recent maritime delimitation case by adopting as the boundary a line that follows a parallel of latitude rather than an equidistance line. Kenya's main argument is that Somalia has acquiesced in such a line. Madam President, Somalia has never agreed or acquiesced that the boundary should follow a parallel of latitude. Our council today will elaborate on what Somalia definitively showed in its written pleadings. Maritime boundaries cannot, as a matter of law, be established through acquiescence. But even if this were possible under the law, it could not be the case here because the facts demonstrate that Somalia never acquiesced to Kenya's unilateral claim that the boundary was the parallel of latitude. Kenya's argument that the court should adopt the parallel of latitude as the boundary, even if Somalia never acquiesced in such a line, to reach this conclusion, Kenya would have the court dispense with the three-step method. Instead of that standard method, Kenya, in its own words, asks the court to apply a code parallel of latitude delimitation methodology, end quote. This is not a methodology that has ever been recognized, let alone applied by the court, or by any other international court or arbitral tribunal. We cannot help but believe that it has been invented by Kenya, it is made in Kenya, for the sole purpose of justifying its claim. It's an obvious contrivance that puts the cart before the horse. It presupposes Kenya's desired outcome, and it is highly prejudicial to Somalia. As such, it fails to produce an equitable solution as the law requires. Madam President, Kenya has not only claimed an extensive maritime area on Somalia's side of the equidistance line, but has also sought to exploit it. In particular, Kenya has authorized exploration activities, including seismic testing and drilling a well in the maritime zone claimed by Somalia. Somalia considers that these activities in a disputed area violate UNCLOS and customary international law. In its written pleadings, Somalia called for full reparation, including compensation for these violations. But we have come before this court in a spirit of peace and goodwill, seeking neither vengeance nor retribution. In this spirit, we have decided not to insist on compensation for past violations of our maritime rights. Madam President, members of the court, it is now my honor to lay out the organization of Somalia's presentations. Following me to the podium this afternoon will be Professor Alain Pellet. He will address Kenya's errors of law on the issue of acquiescence. He will show that it is not possible to establish an international maritime boundary by unilateral action. In the absence of an express agreement or a judicial determination, the establishment of a maritime boundary requires, at very least, tacit agreement. This, Professor Pellet will explain, is an exceedingly high bar to meet, and one cannot be met in the circumstances of this case. Professor Philip Sanders, QC, will then show why the facts do not support a finding that Somalia acquiesced in Kenya's unilateral declaration of a maritime boundary. The record is replete with contradictions in Kenya's position, including statements Kenya made in oral hearings before the court more than 4 years ago. Members of the court who heard Kenya articulate its preliminary objections in September 2016 will recall that Kenya took the view that the boundary remained to be established, not that it had already been agreed or acquiesced to. The argument that Kenya made before you then is directly at odds with the argument it makes now that a maritime boundary came into existence by virtue of Somalia's acquiescence. Having shown that Kenya's acquiescence argument must fail,
الدافع جوتشي عادل جودة عادل كوبت فرن مركا وكان عيارتيغا ضد weerarka ka ciyaarayay kulanka oo markana qalad garsooraha oo Yusuf qalad baa uu qabtay haatan ciyaartooyga ee kooxda maaliyada hal ciyaartooy xaaladiisa markan hakad baa uu galiyay ciyaarta garsoore Yusuf Osila markan bedel ayaa dhacaya daawadayaal bedelkii koowaad ee natiijada ciyaarta bedelkii labaad buu keenay tababare Cabdi Muuse 42 Sakariya Baasha waa baxay Diyo waxa soo galay Cumar Cali lambarka 6 ayaa soo galay haatan kooxda Gaashan ciidanka qaranka Maxamed Dooxe marka ciyaartooyga waa keenay haatan Cumar Cali waa soo baasay Xamse Shulaaca waa ka baxday lugtiisa Ahmed Hindi Subeer dhaxjoog Subeer dhaxjoog marka ciyaartooyga waa ka baxday lugtiisa daafaca Aydaruus Maano 11 marka ciyaartooyga Saciid Maano marka Saciid waa ka baxday lugtiisa قاعد تورش مركا عيارتويغا عمر علي قاشان وكبحضي مر لبادة عيارتويغا قلت باباسو بحيي مالية قيبتا ويركا فرصدي أبو ريان عيارتا سعودتا داوضيالا وهاتن قلبتا عيارتا إبر ماها هل قول إبر بالا إسلام ريا هل كيبي كالفرديان كالهورينتا دبعاها هوريالكا كوبدا عكتا سومالي لانا صدح دبعو تيم كمالية دباهيستا دبعاها سربي ربانين مركان آدانا قاسان أفر دبعود بها هستان عيدان كقرنكا قودير شان دبعود بها هستان وبوسك أفراد بفرديانا بوسك صدحات بفرديانا قودير لمن كالين تلباد قناع سيقايا عيدان كأسلوب تباكودة شرا كالين تكوباد كوحدة هرقيسة سيتي كلاب الدولة دوسي هرقيسة markan daawadayaal daafaca tababaraha Gaashan laba ciyaartooy buu bedelay laba isku boos buu labadaba keenay weerar buu ku bedelay khadka dhaxa buu ku bedelay maaliyada ilaa hadda bedel ma sameyn oo eeganaya ciyaarta socota oo hal gool bay ku hogaaminayaan natiijada ciyaarta isku dhibasho Abdi Karim Gucci kabtanka Gaashan taaxu qadka dhexe markan ciyaartooyga maaliyada gadaal bay ku jiraan Amin kontra Badeeco Maano isku dhibasho fursad baa markana dayacay ciyaartooyga weerarka maaliyada Ahmed Hindi isku dhiibashada cayaartooyga khadka dhexe ugu kubataabashada badan cayaarta maaliyadda markan waa baxday haatan daawadayaal ee gacan tuurasho wasaaradda maaliyadda gaashaan hal gool iyo eber baa la isla marayaa waa daawanaya murabbaca waa daawanaya cayaarta socota dhamac galas waa daawanaya cayaarta socota daawadayaal ee qaybtii dambe tababare iidaan iyo tababare cabdi muuse qisa ayaa hargeysa stadium ku dhex maraysa 90kii daqiiqo bedel baa keenay haatan 22 waa soo galay liibaan cabdi cali maana waa baxay weeraryahankii qaybta dhexe ka cayaariyay qaybta weerarka tababare iidaanna markan weerar buu weerar ku bedela cayaarta galabta waa la is eeganayaa xilli 90kii daqiiqo qaybtii dambe lagu jiro telefishinka qaranka Somaliland cayaarta socota haatan isku dhibasho gaashaan caadil guji waa ka baxday lugtiisa marka cayaartooyga caadil waa keenay guji alkabitaano oo caadil good marka lambarka 7 waa soo baasacay daruus ayto caadil waa ka baxday lugtiisa haata cayaartooyga lambarka 20aad ee kubad furan baa keenay cayaartooyga mustafa umme subeer dhex jooga oo kubad sare markan amiin badeeco amiin badeeco cayaartooyga gaashaan xamse shulaaca guji markan sallo alkabitaano kabtan salebaan cabdikariim guji haatan cayaarta waa socota isku dhibasho xamse agadahable guji mustafa umme markan waa baxday haatan gacan tuurasho haatan cayaartooyga gaashaan maaliyadda hal gool iyo eber bay maraysaa haatan natiijada cayaarta يا أمين ستار 7 ماليدة أمين بديعو ولا قد دفاع مركان عبد كريم قوتشي برتمها قرونكو كباسية هاتنا عيرتيغا عيدروس علي قوتشي عمر علي وباسي مركا عيرتيغا محمد كوري وكبح لوكتيسا قاسان ماليدة قلب دفاع مو أضي سليبان كالو الكابيتانو مختار عسكا تورينو يسكوني بس مركا عيرتيغا تاحو markan qalad buu galay 19 khadka dhexe kooxda wasaaradda maaliyadda gaashaan hal gool bay baadi goobayeen cayaarta maaliyadda waa laalinaya natiijada cayaarta qadar caska waa ka baxday lugtiisa haatan عيرتيغا عادل قودي عادل 7 مركا عيرتيغا احمد هندي عادل قودي يسكني بشو امين بديعو عيدروس علي جوتشي الكابيتانو وكبح لي لوكتي سمركا عيرتيغا عيتو ciyaartana daawadayaal hal gool iyo eber bay maraysaa barbaraha lama saadaalin karo 90 daqiiqo oo shabaga Hargeysa Stadium daafaca marka waa soo baasay gaashaan daafaca lugta bidix markana subeer dhex jooga lambarka 6 maaliyadda super sita marka waa ka baxday lugtiisa ya Hargeysa Stadium tababara diridhaba 9 dhibcood buu haystaa xilli la ciyaarayo horyaalkii kubadda cagta Somaliland kulamada soo socda maalinta bariya natiijada waa la kala bixi doonaayo ganacsiga iyo kooxda ciidanka asluubta hadii rabiidma telefishinka qaranka ayaad kala soconaysaan sidoo kale Somali score ciyaartana daawadayaal waxa ay maraysaa ilaa hadda hal gool iyo eber galabta ciyaartan lama saadaalin karo oo 90kii daqiiqo la islama aadin liibaan cabdi cali markana isku dhiibasho guji qalad baa u galay markana kabtanka gaashaan haatan fursad baa ay heleen kooxda wasaaradda maaliyadda marka cayaartooyga ee wasaaradda maaliyadda daafaca gadaal bay galeen midabka huruudda bay ku cayaarayaan kulanka galabta 2020kii hore baan idinku sheegay qisadii dhex martay 2021 sagaashanka daqiiqa bayna ogaan doonaa cidda halkan kala baxda daawadayaal cabdikariime guji baa marka soo baasay mustafa uma loo baasay umme waa soo maray isku dhibasha waa keenay kantarool mawliid qoorcin mawliid waa ka baxday lugtiisa alkabtan salebaan كالو وبحذي هات عيرتيغا محمد دوحي جوتشي كنترول الكابتن يا جوتشي 63 وصوباس عيرتيغا عيدروس عادل جود عيدروس علي عادل جود كوبت فرن مركنا يا مصطفى امي كنترول مصطفى امي جولات يا ورسمه بيد مركنا جول كواقبت عيارتيغا وزارة مالية جولك وزارة مالية ورسمه هيا قبتي هاتن عيارتيغا جولك وهيا تيم كمالية عيارتا قد
La Chambre de la Cour y a vu un principe, je cite, d'application des parties à cet accord qui, j'y reviendrai, doivent être clairs et sans équivoque. C'est vrai aussi pour les accords entraînant un changement de titulaire de la souveraineté territoriale. Comme y a insisté le TIDM, aucun État, et je le cite, ne saurait arrêter ses limites maritimes de façon unilatérale, et celles-ci doivent au contraire l'être par voie d'accord, entre les États concernés, ou par le recours aux procédures de la partie 15 de la Convention des Nations Unies sur le droit de la mer, si les 10 États ne parviennent pas à un accord dans un délai raisonnable. Au détour de certaines phrases de ces écritures, le Kenya s'en est d'ailleurs déclaré d'accord. C'est le cas par exemple dans ses exceptions préliminaires, où il expose que, je cite, en anglais, "The parties expressly agreed on a negotiated settlement of their maritime boundary. This was consistent with Kenya's legislations requiring the limitation by agreement with Somalia. It was also consistent with the provisions of UNCLOS." End quote. Comme le Kenya le relève dans son invraisemblable document daté du 22 février, c'est lui qui a initié une réunion avec la Somalie qui s'est tenue à Nairobi les 26 et 27 mars 2014 pour discuter de la frontière maritime sur la base du nouveau différend. Comme l'a fait remarquer avec un grand bon sens la Chambre du TIDM dans Ghana contre Côte d'Ivoire, je la cite, « Le fait que des négociations et échanges bilatéraux sur la délimitation d'une frontière maritime se soient tenus entre les parties indique l'absence plutôt que l'existence d'une frontière maritime. Si un accord est indispensable, et il l'est, il n'est dès lors pas douteux qu'essayer d'établir unilatéralement des limites internationales sans tenir compte de la position juridique d'autres États est contraire aux principes reconnus du droit international. C'est ce qui a conduit, vous avez dit l'affaire du plateau continental Tunisie-Libye, et c'est ce qui a conduit le tribunal arbitral constitué dans l'affaire des deux Guinées à refuser de, je le cite, prendre en considération une délimitation qui ne résulte pas de négociation ou d'un acte équivalent, conformément au droit international. Or, en l'espèce, la prétendue délimitation a été effectuée par un acte juridique relevant du seul pouvoir de la Guinée et susceptible, comme ceux qui ont été pris par cette même Guinée au nord et à la même période, de faire l'objet de modifications unilatérales. Fin de citation. Or, mesdames et messieurs les juges, c'est très précisément ce que le Kenya voudrait vous faire décider dans la présente affaire. Il vous demande de consacrer le traité unilatéral prétendument adopté par lui au prétexte du silence, également prétendu, gardé par la Somalie. Ceci revient à mettre en cause le principe fondamental de l'accord dont, je le rappelle, le recours à une délimitation par voie arbitrale ou judiciaire n'est en dernière analyse qu'un succès d'année. C'est que le Kenya est embarrassé par cette exigence d'accord. Il est conscient qu'il n'y a pas davantage d'accord tacite que de traité express fixant le tracé de la frontière et que les conditions très strictes mises par la jurisprudence à l'existence d'un accord tacite, comme d'ailleurs un acquiescement, et je vais y revenir, ne sont pas remplies en l'espèce. Du coup, il met la sourdine en ce qui concerne l'existence prétendue d'un accord tacite, dont il s'efforce de parler le moins possible en tant que fondement de sa prétention frontalière. Et il insiste précisément sur quelques comportements unilatéraux qu'il impute à la Somalie et qui constitueraient la preuve de l'acceptation, de l'acquiescement ou du consentement de celle-ci. Autrement dit, il se fonde sur des comportements purement individuels et toujours tacites, il ne s'agit que de silence, comme si ceux-ci pouvaient constituer des justifications autonomes établissant la frontière défendue par nos adversaires.
'24 of his counter memorial, and I quote, "The 1979 EEZ proclamation was thus both declarative and prescriptive and entailed rights and obligations for other states. This is indeed unilateralism in all its splendor." So even when it expresses itself in less of a caricatural manner, the starting point of Kenya's arguments is always made up of its own unilateral decisions. An example, amongst others, is in paragraph 206 of its counter memorial, and I quote, "First in 1979 and again in 2005, Kenya officially notified other states, including Somalia, that the single line of maritime delimitation with Somalia up to 200 nautical miles limit of the EEZ followed the parallel of latitude." End of quote. Kenya has not offered to proceed with negotiations in view of delimiting the border through an agreement. It is informing the international community of the delimitation line that it has decided on by itself. And such examples are numerous. The border having been established by the declarations made by Kenya, it is therefore up to other states to protest against this. I quote, "Kenya's case is that Somalia had a duty to react if it opposed Kenya's claim, and Somalia's prolonged silence therefore constitutes consent to maritime delimitation based on the parallel line." End of quote. As against the very fundamental requirements of the agreement, this position of Kenya justifying the creation of maritime boundary by one or several unilateral actions is legally untenable. By assuming as a premise an obligation to oppose a claim, Kenya is actually reversing the well-established presumption according to which unilateral acts of a state do not create obligations for third parties. The Commission for International Law recalled in the guiding principles applicable to the unilateral declarations of states in 2006, and I quote, "No obligation may result for other states from the unilateral declaration of a state. However, the other state or states concerned may incur obligations in relation to such a unilateral declaration to the extent that they clearly accepted, I repeat, clearly accepted such a declaration." End of quote. Silence is not enough. A positive manifestation of acceptation is required, as demonstrated in the arbitral award rendered by the King of Spain that was mentioned by the Chamber of the Court in the Gulf of Maine case, that it did not constitute, I quote, "a valid precedent." Acquiescence did play a part in that case, but in reaching that conclusion, the court relied on explicit declarations of Nicaragua and on conduct that had continued, I repeat, and on a conduct that had continued over a very long period, something which does not apply in the present case. It is not possible to lightly attribute to silence the radical effects of this silence for Kenya, and this is even more so when it concerns abandonment or transfer of territorial sovereignty and sovereign rights. Indeed, as Kenya mentioned in its second rejoinder, you have accepted in the Pedro Branca case that there was a change in the holder of sovereignty and that this could result from a tacit agreement, and I quote, "arise from the conduct of the parties," end of quote. But you also underscored that international law does not, in this matter, impose any particular form. Rather, it places its emphasis on the parties' intentions. And even further, in a passage that Kenya refrained from quoting, the court insisted, I quote, "critical for the court's assessment of the conduct of the parties is the central importance in international law and relations of state sovereignty over territory and of the stability and certainty of that sovereignty. Because of that, any passing of sovereignty of territory on the basis of the conduct of the parties must be manifested clearly and without any doubt by that conduct and the relevant facts. That is especially so if what may be involved in the case of one of the parties is in fact the abandonment of sovereignty over part of its territory. To accept Kenya's theory would be to admit that a unilateral declaration constitutes an injunction to react from the moment it is internationally notified, failing which the contravening party would be presumed to be bound. Madam Chairperson, an agreement is indispensable to delimit a boundary, whether it be a land boundary or a maritime boundary. And my colleague Philippe Sands will demonstrate that such an agreement, tacit or even more so express, is nowhere to be found in the current case. Distinguished members of the court, this is not to say that never before, regardless of the circumstances, has a delimitation resulted from a tacit agreement. But even if there is no trace of such in our current case, I would nonetheless add that from a legal standpoint, the conditions that are required for the existence of such an agreement for delimitation are particularly strict. As the case law points out, and that is well established, according to the very firmest wording of the court in its judgment of the 8th of October 2007 in the Nicaragua versus Honduras case, evidence of a tacit legal agreement must be compelling. The establishment of a permanent maritime boundary is matter of grave importance, and agreement is not easily to be presumed. End of quotation. In an absence of a written agreement makes it particularly difficult for the state invoking such a tacit agreement to prove its existence. In a recent case that you're familiar with, it is emphasized in particular the importance of a written document as proof of a tacit agreement. In Peru versus Chile, the court recognized the existence of such an agreement, but in order to do so, it based its conclusion on the pre-existence of a treaty recognizing the maritime boundary approved by both states. And therefore, the court deemed that the instrument was indeed a decisive element in this respect, cementing the tacit agreement. It was indeed an express agreement that provided the proof of a tacit agreement.
In the present proceedings, Kenya is not daring to claim at the moment that it requires a written proof of acquiescence, but has claimed that, quote, there is no question that a state opposed to the claims of another state, especially when it affects its sovereignty and sovereign rights, must protest if it wants to prevent acquiescence. End of quote. In other words, silence, interpreted as meaning an absence of protest, would apparently embody acquiescence when the claim or assertion of another party would be made publicly. According to Kenya, mere constructive knowledge is sufficient for acquiescence. Now, I don't really know what is meant by mere constructive knowledge, but I know that simple knowledge, rather uncertain in the current proceedings, of a position cannot equate to acquiescence. Contrarily to the assertions made by Kenya, it is a party which invokes a tacit agreement rather than that which denies its existence that it comes to prove the factual situation. The demand to the contrary would therefore put pressure on the party denying action to provide negative proof, which is almost impossible to do. It is up to Kenya, therefore, to prove via positive evidence that there has been consent, a clear agreement by Somalia to the boundary course invoked by Kenya. Kenya makes great play of the agreement which it seems to detect between the parties as regards the conditions which an acquiescence is supposed to meet, using the claim that both refer to the definition of the arbitral tribunal in the affair of the boundary delimitation between Ethiopia and Eritrea. But firstly, that is to overlook the fact that, as we have stressed in our reply, and as I have just reiterated, acquiescence is not a means of maritime delimitation which is adopted by UNCLOS. Even if one were to set aside this convention, which would hardly be acceptable, Kenya has mischaracterized the conditions which have been expressed by the Eritrea-Ethiopia Tribunal and bases itself on a very selective version of case law, which it interprets in a very controversial manner. The case law, the jurisprudence, is very clear and well established. As has been firmly underlined, acquiescence is not proven by an absence of reaction. It has to be evidenced by positive fact. Since 1969, in the cases relating to the continental shelf in the North Sea, the court has stressed that the court does not show opposition and cannot be presumed to have acquiesced on the basis of its silence alone, which can have a multitude of different meanings. It's no doubt that you said in the result it appears that the court, that none of the reasons invoked is decisive. Each is ultimately negative or inconclusive, all are capable of varying interpretations or explanations. Even if the Federal Republic was not specifically opposed to the equidistance principle as embodied by Article 6 of the Convention, from a purely negative conclusion such as this, it would not be possible to draw the positive inference that the Federal Republic, though not a party to the Convention, had accepted the regime of Article 6 in a manner binding upon itself. In the Tunisia-Libya case, the first case in which the question of a tacit agreement arose, the court refused to accept that there was a tacit agreement on a definitive basis in the fisheries activities which were carried out on both sides of a line separating the banks of sponges of both parties, fixed by Italy in its municipal law and respected by Tunisia. Indeed, as you stated at the time, and I quote the court, the evidence of the existence of such a modus vivendi, resting on only on the silence and lack of protest on the side of French authorities responsible for the external relations of Tunisia. Equally, in the Gulf of Maine case, the chamber of the court had not upheld the claim of Canada based on the silence that was kept by the United States towards Canada's claims. And in the Libya-Malta case, Libya had explained, and I quote, that it had informed Libya of its intention to delimit its continental shelf by a median line, and that it had remained very silent in front of, when confronted with this Maltese request. It remained silent in the face of Malta's claim to such a delimitation, and Malta therefore saw this as proof of acquiescence by Libya, which prevented it, in law as in fact, from challenging the Maltese position. The court rejected this reasoning. The arbitral award, which was in the case opposing Newfoundland and Nova Scotia, unfortunately, this award doesn't exist in French, but I'll quote the English. In the maritime boundary cases, it has often been argued that the cases have, by conduct, established a particular line or consolidated some aspect of a maritime boundary. Such arguments have always been treated as admissible and been carefully considered. But it must be said that more often than not, they have been rejected, either because the conduct did not relate to the area in question, or was merely unilateral, or was performed vis-à-vis a third party, or was an exercise in self-restraint to avoid aggravating the dispute, or was equivocal. In this same award between Newfoundland and Labrador against Nova Scotia, the tribunal claimed that in order to establish a boundary not settled or determined by agreement has been established through conduct, it is necessary to show an unequivocal pattern of conduct as between the two parties concerned relating to the area and supporting the boundary. End of quote. And in order to reach this decision, the tribunal noted particularly that Nova Scotia and Labrador had expressly accepted the method of delimitation which had been taken on board. Kenya based themselves essentially on 4 cases, and I'm sorry to inflict upon you, Madam President, and distinguished members of the course, various case law, but in the case of Pedro Branco, which I mentioned a few moments ago on a similar matter, the case relative to the Temple of Prevear, the decisions that had been rendered in the dispute between Eritrea and Yemen, and the arbitral award of the 22nd of December 1963 concerning the interpretation of the Air Transport Services Agreement between the United States and France. Now, It's hardly necessary to discuss this final case, which neither covered a boundary dispute nor did it cover questions of territorial sovereignty. In fact, the decisive element which led the arbitral tribunal to decide on the existence of a tacit agreement was the fact that consent by France had been given within the framework of negotiations and echoed by a formal letter giving an express recognition in writing of acquiescence, whose logical interpretation was confirmed by the subsequent practice of the parties. In a similar vein, referring to Pedra Branca, the court had sufficient detailed evidence, and it was expressed rather than tacit, in the correspondence of 1953 between Singapore and Johor, noting that the Johor noted that sovereignty on Pedra Branca or Pulau Batu Putih did not belong to it. It did not have sovereignty over Pedra Branca, Pulau Batu. And therefore, these circumstances are only distantly related to the present proceedings. Furthermore, if one turns to similar cases, they have a very high threshold to establish the abandonment of sovereignty or of sovereign rights. But whereas the occupation of a land-based territory, even if one only deals with an island, is something tangible and easy to observe, things are very different when you're dealing with maritime effectivité. In fact, Kenya is the last country which can really accuse Somalia for not having protested against the encroachments on the sovereign rights of Somalia, which it was responsible for, when it insists, vocally, if not somewhat indulgently, on the help given to its neighbour weakened by civil war, including to try and ensure its maritime security. Kenya recognizes it in the voice of its own agent, who contradicts, indeed, the witness statement made by General Kwabana. And I quote, "Somalia," the Kenyan agent said, "has only recently begun to emerge from a long period of instability caused by civil war, humanitarian disaster, and widespread terrorism. In particular, I stress that, Somalia has no maritime enforcement capacity. Somalia has no maritime enforcement capacity," said the Kenyan agent. And indeed, it has been lacking in this maritime enforcement capacity until very recently. It's very difficult for Kenya to claim at the same time that Somalia lacked vigilance in silently allowing its sovereign rights to be taken over without response. The situation is very different from the situation in the Eritrea-Yemen 1998 case, in which Kenya seems to make great play of this award. I would add that effectivité are likely to become of greater significance when dealing with land-based boundaries, as there are no rules generally applicable in this field. Things are very different if one deals with maritime boundaries. The rules are clearly fixed, you need an agreement, and these rules cannot be overturned by creating a fait accompli. The analogy between the present proceedings and the temple is also not convincing. Unlike Siam, Somalia has not been involved in preparing jointly a map drawing up its maritime boundary with Kenya. Certainly in 2008, when the civil war was reaching its height of violence, it did receive a map which was drawn up unilaterally by Kenya. This map was annexed to a note verbale in which Kenya insisted for Somalia to agree with the maritime boundaries between the two countries. But this episode cannot be compared to the multiple occasions in which Siam very officially had received the maps that it would challenge 50 years later. Finally, and above all, One needs to note that, unlike Siam, Somalia challenged the course of this boundary in the Memory of Understanding, signed less than a year later, when the two parties agreed, and I quote, "The delimitation of the continental shelf between the Republic of Kenya and the Somali Republic has not yet been settled." This unresolved delimitation issue, I stress the words, between the two coastal states is to be considered as a maritime dispute. And once again, in the negotiations which were held in Nairobi in 2014 on the initiative of Kenya, the two delegations noted, and I quote, that after considering several options and methods, including bisector, perpendicular, median, and parallel of latitude, they could not reach a consensus on the potential maritime boundary line acceptable to both countries to be adopted, the potential maritime boundary line. Kenya has also based itself on an incidental sentence that it draws from the judgment that you rendered on preliminary objections in the present proceedings. You had stressed that Somalia had never directly notified Kenya of any alleged defect in its consent to be bound by the Memorandum of Understanding of the 7th of April 2009. But there is a gulf between insisting on the nullity of a treaty concluded between two states and tacitly carrying out maritime delimitation. And the doctrinal authorities, rare as they might be, that are invoked by Kenya, are not really going to be of greater assistance. They are rather vague and general and have very little links to the case which is of current concern. I would, however, make one exception, which is the article of Herr Schlauterpacht on the sovereignty of submarine areas, both because of the eminence of its author and also the relative insistence with which our opponents have invoked it. But there is no need to tarry on it. The aim of this article, which was written in 1950, was to justify the lawfulness of American and British proclamations about the continental shelf, particularly by stressing the absence of oppositions in principle by other states, which did not prevent Lauterpacht from recalling that ab injuria jus non oritur, saying that one cannot stress too much in the present proceedings. So it falls to Kenya to prove, rather, not that Kenya remained silent, but that it had clearly accepted its unilateral definition of a claim, at least tacitly. And this acceptance has to be clear and devoid of any ambiguity. It has to at least be deducible without a shadow of doubt from its conduct. This claim of an acceptance does not leave any room for case law. It has to be perfectly clear and consistent, which is not just subject to maritime delimitation, but has been upheld, the case law that is, by dating back to at least the affair of the case of the continental shelf of the North Sea. As Charles Fisher has noted, or Charles de Visser has noted, one notification cannot give rise to a particular reaction. No reaction is possible. The addressee can keep silence, whether one is allowed to conclude anything from this or not. One cannot oblige states to invariably protest against all assertions that political calculations can attribute to their silence. In fact, this kind of argument has never convinced international courts or tribunals when it has been called upon to rule upon a tacit agreement. None of them, not one. One needs sufficiently clear conduct, sustained and consistent, to constitute acquiescence. Even when confronted with this kind of conduct, they have considered that a de facto line might be more in the nature of a provisional line or of a line for a specific limited purpose, such as sharing a scarce resource. Even there had been a provisional line found convenient for a period of time, this has to be distinguished from an international boundary, the court ruled in Nicaragua versus Honduras. The case law also indicates that the constancy of conduct of two parties, even if spread over a long time, is not sufficient to show an agreement. This is the result of a second strand of the Continental Shelf Tunisia-Libya case, in which Libya had based its petroleum blocks on blocks that had been drawn previously by Tunisia, and both states had rejected this de facto line in carrying out seismic exploration and for carrying out as well numerous drilling projects without any protest from the other party. Despite this conduct, the court nonetheless concluded that this line has been found by the court to be wanting in those respects necessarily to ensure their opposability to the other party. Equally, in the Libya-Malt judgment of 1985, the court rejected Malta's argument according to which the common line of border concessions and petroleum blocks was any pattern of conduct on either side sufficiently unequivocal to constitute either acquiescence or any helpful indication of any view by either party. In Nicaragua, Honduras, having noted that at periods in time the 15th parallel appears to have had some relevance in the conduct of the parties, the court refused to conclude that there was a legally established international maritime boundary between the two states. And more recently, in the case of maritime delimitation between Ghana and the Côte d'Ivoire at one of the ITLOS special chambers, the applicant state advanced a tacit maritime boundary which had been respected for 50 years and which was valid for all of the maritime areas covered by the parties. So as to do this, Ghana based itself principally on the oil practice of the parties and more precisely on the petroleum blocks granted by the two states, seismic surveys, drilling activities, and the maps of petroleum blocks. Ghana had also shown that the blocks that had been granted had been aligned on an equidistance line and that each of the parties had been confined the oil activities carried out by each of the parties had been confined to an area lying on the respective party's side of the line. And each party requested and obtained the other party's permission before crossing this line in order to conduct seismic surveys. So despite the abundance, the concordance and the variety of such evidence, the special chamber concluded that the oil practice, constant as it may be, was not sufficient by itself to establish a tacit agreement on a maritime boundary. It was also not convinced by any of the other proof that was invoked by Ghana, and the Chamber therefore considered that the legislation adopted by the two parties, the requests submitted to the CLCS, and bilateral exchanges between the two states did not allow one to conclude on a tacit agreement on a maritime or border boundary. So, Madam President, without wishing to encroach on some of the demonstration of facts that falls particularly to Philip Sands, I would like to note that so as to appreciate the scope of the conduct of Somalia, certain precedents seem to be of particular importance. This is the case, for example, in the cases noted by the ITLOS Special Chamber, Ghana versus Le Côte d'Ivoire, in which they noted that the parties agree that bilateral exchanges took place, but differ as to their exact content and significance to the present dispute. In the present chamber's view, or in the special chamber's view, the fact that these bilateral exchanges took place at all is relevant because it shows that the parties recognize the need to delimit a maritime boundary between them. So I think that one also can quote the ITLOS Special Chamber in saying that the subsequent bilateral negotiations at the Commission of Maritime Border Demarcation between 2008 to 2014 confirmed the parties' recognition of the absence of a maritime boundary between them. In Nicaragua versus Honduras, the court noted that the latter had accepted in an exchange of notes in 1977 to initiate the preliminary stages of discussions about the the definitive and marine and submarine delimitation in the Caribbean Sea zone. Between Honduras and Nicaragua had not been legally delimited. According to the court, referring to the Minky and Ekrahus case, this recognition should thus be taken as evidence of Honduras' official view at that time. Having reviewed all of this practice, including the diplomatic exchanges mentioned above, the court concludes that there was no tacit agreement in effect between the parties in 1982, nor a fortiori in any subsequent date, of a nature to establish a legally binding maritime boundary. The same also applies to the Bangladesh-Myanmar case that was judged before ITLOS, where the ITLOS tribunal concluded that a note verbal had been sent by Myanmar to Bangladesh, giving details of the fact that the parties had yet to delimit a maritime boundary. And this did not demonstrate the existence of a tacit or de facto boundary agreement concerning the territorial sea. Taking into account all of the above, one can conclude that a constant and a mutual practice over a long period of time is not sufficient so as to conclude on the existence of a tacit maritime boundary. Then, secondly, exchanges of notes, not notes sent with no reply, and the conduct of negotiations have considerable weight to bear in the judgment of evidence presented by the parties to the dispute. However, the silence kept by one of the states concerned is not sufficient to confer the status of a tacit agreement to a modus vivendi, even if over a long period of time on the ground or indeed on the unilateral decisions taken by the other state. And furthermore, the time, whilst it might play a certain role in establishing a tacit boundary, must be consistent with the circumstances of the case and the active conduct or inaction of the parties. Madam President, as I have said, this is not just a twist or a hip-hop which one can dance solo, but a tango, which is to be dominated by a pas de deux. Not only the conduct of the applicant state has to be constant, but coherent, but it must also be reflected identically by the conduct of the other party. As my colleague and friend Philip Sands is now going to demonstrate again, if you would be kind enough to give him the floor, his unilateral proclamations and the attitude of Kenya in general do not have either the significance or the constancy required in the present proceedings. And the same applies to the sporadic conduct of Somalia, which is invoked by Kenya and which does not have either the significance or the constancy which is required in the present proceedings. Distinguished members of the court, I would like to thank you for your attention. And, Madam President, if I can ask you to invite Professor Philip Sands to take this virtual podium. Thank you.
Thank Professor Alain Pellet. Before I invite Professor Sands to take the floor, the court will observe a coffee break. of 15 minutes. The seating is adjourned.
daawadayaal halkani waa Iftiin Somali TV si aad noola socotaan waxyaabaha soo gelino page-kayga le kare siina share garee si aad u daawato barnaamijyo ku xiiso geliya iyo warar xaqiiqada ku saabsan sidoo kale kala soco sportiyada iyo musalsalo iyo waxyaabo badan oo ku xiiso geliya fadlan YouTube-ka subscribe noo saar daawadayaal halkani waa Iftiin Somali TV
hadii lagu yiri badrool badan baa
daawadayaal halkani waa Iftiin Somali TV si aad noola socotaan waxyaabaha soo gelino page-kayga le kare
hadii lagu yiri badrool badan baa halka ku jira biyaha aniga iska leh qarankani baa ma noqon dhulkayguna boob ma galo batayduna iib ma aha qarankani baa ma noqon dhulkayguna boob ma galo batayduna iib ma aha Barrigayga iyo
daawadayaal halkani waa Iftiin Somali TV si aad noola socotaan waxyaabaha aan soo gelino page-kayga le kare
يا أخي عندنا كتاب ولا قال يا أخي كسابيو.
إيه أنا